an asylum story so improbable, so against the odds that even I, with all my years of experience in asylum law, was truly shocked by. Now, this is pretty much an asylum miracle, a success story of a sort that is incredibly rare. Now, during my time as an asylum officer, I never saw anything like it, and I'm not aware of other lawyers achieving what I'm about to tell you today. And I think this case study is going to give you hope if you're someone who currently has lawful immigration status, including temporary protected status or tourist status, and you're concerned about the asylum interview that you're eventually going to have with USCIS. I'm going to explain why there's more hope than you might think for your asylum case, and we're starting right now. I'm Brian Manning, and I used to be an asylum officer with the government, but now, as an asylum lawyer, I help immigrants all over the country to secure their future in America through asylum. Let me know in the comments if you've got an asylum case pending, or maybe you're just considering applying. Listen, I'd especially like to hear from you. If you've been waiting for an asylum interview for multiple years, let me know how long you've been waiting.
Today, we're doing a case study that proves that even when all hope seems lost, there can still be a path to success. We're going to explore the challenging, often frustrating process of fighting for asylum after receiving a notice of intent to deny and then a final denial from USCIS. You see, while it's extremely difficult, you can sometimes still win your asylum case when up against these very long odds. This is about how my law firm actually succeeded with what's called a motion to reconsider. This is so rare that during my time as an asylum officer with USCIS, I don't think I ever even saw anyone attempt to do one of these. First, let's quickly go over how the process typically works when you get a negative decision from USCIS. They look at your immigration status at the very moment they are making that negative decision. Most commonly, people don't have valid immigration status at that point. Their tourist status might have long expired, or whatever their status was, they no longer have it. When that happens, USCIS sends your case to an immigration court, placing you in deportation proceedings. USCIS tries to frame this as something other than a denial, making pains to characterize it as a referral. But let's be clear, it's effectively a denial because they've concluded you don't qualify for asylum, and the government is now actively trying to deport you. While you do get another chance to present your case to an immigration judge, it's a serious situation because the government is actively working to remove you from the United States, and you are one step closer to deportation. However, the process is different if you still have valid immigration status at the moment USCIS makes a negative decision after your affirmative asylum interview. In such cases, USCIS issues what's called a Notice of Intent to Deny, or NOID as it's commonly called, for its initials. This NOID letter typically outlines, in at least some detail, the officer's reasoning for why they believe you don't qualify for asylum. Now, these NOIDs are usually not very detailed. They often provide a brief summary of your interview testimony and then attempt to apply those facts to the law. Frustratingly, these letters are frequently generated from a copy and paste template, and sometimes they forget to update information from old versions. This can lead to receiving a NOID with other people's information or nonsensical statements. You have 16 days from the date on the NOID letter to reply in writing and try to change their mind. This is called a rebuttal, and it's an extremely difficult task. I would estimate the chances of success are probably less than 5%. However, we have had recent success in the last few months, with 3 of these rebuttals getting approved. So if you get a NOID, just know that there is hope, but you need to act fast. You should contact an asylum lawyer immediately because the time frame to respond is short. Remember, you only have 16 days, and it takes a lot of work to produce the kind of argument that has even a remote chance of being successful. In the rebuttal, you're making legal arguments demonstrating why the officer made errors in their reasoning and conclusion. It's challenging because officers and their supervisors are naturally reluctant to admit mistakes, but it is not impossible. As I mentioned, we've achieved success with these a few times recently. By the way, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and bell notification so you don't miss the insights that I share on this channel. Okay, so after you submit your written rebuttal, or if the 16-day period lapses without a response, USCIS will issue an automatic final denial. If you submit a rebuttal, they will consider it to see if you've changed their minds. If you succeed, they will grant your asylum. But if you don't, they issue what's called a final denial. The final denial letter is usually less detailed than the NOID, offering only a sentence or two summarizing why they believe the applicant is ineligible for asylum. It essentially states, "You didn't change our minds." Most immigration lawyers, and even many asylum seekers, don't know this, but there is effectively a way to appeal a final denial. But before I tell you about that, you need to know about the potential outcomes upon receiving a final denial. When you receive a final denial, you are not sent to immigration court. In a sense, this is good because you are not placed in deportation proceedings. Instead, you continue with your current immigration status, whatever that may be. Currently, many asylum seekers hold temporary protected status, or TPS, which counts as valid status. So a lot of people are receiving NOIDs and then final denials while maintaining their TPS. They would simply continue with their TPS. The problem is that TPS is temporary and will eventually end. Many, if not most, people with TPS are at risk of losing it imminently due to potential policy changes by the Trump administration. When TPS ends, these people will likely be placed in deportation proceedings. However, their asylum claim will have effectively disappeared. Because it was fully adjudicated by USCIS, the immigration judge is almost certainly not going to reconsider it. This leaves them without a strong defense in immigration court, increasing their risk of a deportation order. The stakes are incredibly high here. It's frustrating for many who, if they knew a negative decision was coming, would prefer to not have lawful status at the time of their USCIS interview decision. They would rather be placed in deportation proceedings to keep pursuing their asylum claim instead of receiving a final denial, which typically means their asylum claim is absolutely over, with no second chance. However, there is a rarely known second chance. Most immigration lawyers are unaware of this, but the Affirmative Asylum Procedures Manual, or AAPM, outlines a process for a motion to reconsider. The AAPM is the procedural rulebook for how the asylum office operates. It allows for a motion to reconsider, which basically means that if you can convince the director of the asylum office that the officer who made the decision committed egregious error, they will reconsider the case. If your motion to reconsider is granted, it doesn't mean you've been granted asylum. It simply means they've agreed to re-examine the case more closely to determine if there was egregious error in the initial decision. Sometimes, they might call the applicant back for another interview. Other times, they will simply review the existing file, including the officer's notes, their written assessment detailing the officer's reasoning, and all the evidence and legal briefs submitted by the applicant's attorney. In our client's case, a Venezuelan national whose identity we are keeping private for privacy concerns, we built a pretty strong initial case. Before his interview, we submitted a comprehensive legal brief, a detailed declaration, and additional evidence. We compiled all of this into what we call our Asylum Roadmap, which is designed to clearly guide the officer to an approval. After our client received a NOID, we submitted a rebuttal, meticulously dissecting the officer's flawed reasoning. The reasoning in this particular NOID was indeed specious and very flawed. We argued point by point, demonstrating why the conclusions were incorrect and inconsistent with the law. Despite our solid arguments, we did not succeed at that stage. Our client received a final denial. However, we then filed a motion to reconsider, as contemplated in the AAPM for cases of egregious error. Now, I usually do not offer this as an option to our clients, as the chances for success are so low that it usually just does not make sense. But if I think there's at least some shot for success, I may broach it with the client and tell them, look, you're almost certainly not going to win this. Even though we think you should, you almost certainly won't, because that's just how USCIS is. But if you want us to move forward with this, we can. To be sure, we only offer this only in rare cases, but this was one of them. To give you a sense for the actual facts underlying this case, and to understand why we believe there was at least some shot for success, it's crucial to know that while this was what I would characterize as a pretty strong case, it was not an overwhelmingly strong case in terms of the facts. In our motion to reconsider, we argued that the final denial represented egregious error because it failed to provide any actual reasoning, instead using a placeholder word, reasons. This was not just a minor oversight. It was so negligent as to be offensive. This reasons field is a section in the template the officer was working from, where they are supposed to write a paragraph or two explaining their specific reasons for why our rebuttal failed to convince them. The officer is required to explain their reasoning here, but instead, they simply left the word reasons in the final document. This level of incompetence is shocking. Not only that an officer produced such a document, but also that their boss, a supervisory asylum officer, signed off on this decision. They are supposed to have read and approved it, and clearly, they did not pay enough attention to catch this embarrassing error. This failure to do the proper analysis violates USCIS's own procedures requiring reasoned decisions, as well as administrative law principles mandating agencies to consider all important aspects of a case. The denial also ignored the detailed legal arguments we had made in our NOID rebuttal. In our motion to reconsider, we highlighted 3 key errors in USCIS's initial assessment, which we had already drilled down on in our rebuttal. First, the officer incorrectly concluded that the client's kidnapping by Venezuelan intelligence agents, who pointed a gun at his head and threatened his life, did not constitute persecution. This directly contradicted USCIS's own training materials, which explicitly recognize such threats and psychological intimidation as persecution. Second, the NOID erroneously failed to acknowledge evidence indicating continued government interest or tracking of the client, even as they attempted to leave their country. The officer was essentially trying to say, hey, you were able to leave your country and pass through immigration in doing so, where they definitely would have checked your identity. If they really wanted to harm you, they could have done so, but they chose not to. The fact that you were able to pass through without problems must mean that they don't really care about you. They don't want to harm you. The officer was stating as a fact that nothing happened when the client left their country, when in fact the client did have a problem at the airport, something they discussed in their declaration and in their testimony at their interview, and the officer just ignored this crucial fact in the NOID. Third, the NOID's conclusion that only high-profile opposition leaders faced persecution in Venezuela was flawed, as extensive country conditions evidence showed that, in fact, most of those subjected to arrests and forced disappearances were not politicians with a known public profile. You see, asylum officers love to cherry-pick information that supports their predetermined conclusion. In cases from Venezuela, they often point to the fact that high-profile politicians have been targeted for harm and then conclude that because you're not a high-profile politician or opposition figure, then you must not therefore be at risk. This argument is logically flawed, and there is actually lots of country conditions information that suggests that it's not just high-profile opposition people who are being targeted for harm. In fact, it's low-level opposition of all kinds. And that's something that my law firm is really good at. We're good at finding this country conditions information to really help us make the strongest legal arguments possible. And in this case, we definitely had that type of information. It was clear that the asylum officer had just ignored the information that we provided to this effect through country conditions reports and the discussion that we included in our legal brief. Okay, in our motion to reconsider, we asked the director of the asylum office to consider these points as well as the various arguments we had made in our rebuttal, which were clearly ignored by the officer. To be honest, I did not have high hopes for success. This just isn't the kind of thing that you can normally win with USCIS. But then, recently, we received the asylum grant. This means we convinced them through our motion to reconsider that they were simply wrong. Not just a little wrong, but that they had committed massive, egregious error. We met that high standard by thoroughly demonstrating through our legal reasoning and writing why the officer's decision was patently wrong. Factually speaking, this was a pretty strong case. I thought there was a pretty good chance it would be granted initially, before the interview. But it wasn't an overwhelmingly strong case, not a clear-cut, 99% sure this case will win situation. There was significant past harm, but it wasn't incredibly severe. There was a clear nexus to a protected ground, but whether the past harm was severe enough to constitute persecution, and whether the person was still at grave risk after many years had passed since they left Venezuela, was also probably an open question, or at least one that was up for debate. But with solid arguments and a ton of effort from my staff, we made it work. This is a message to all of you out there who have legal immigration status, including temporary protected status, and receive a final denial from USCIS. It is worth discussing with an immigration lawyer whether there's a decent argument to be made about egregious error that warrants asking the director of the asylum office to intervene and re-examine your case, potentially overturning the denial. But you've got to act fast. The AAPM sets a deadline of 30 days from the date of the final denial in which you must file a motion to reconsider. And I must stress again that the chances for success are extremely low, even with a pretty strong case like this one, where we had solid arguments. Even in cases I would characterize as strong, the chances for ultimately succeeding once you reach the motion to reconsider stage, after receiving a final denial, are very, very low, under 5%, I have to imagine. But as this case proves, there may still be hope even when you're facing very long odds. If you receive a final denial and you're convinced it's simply the wrong decision, then yes, it does make sense to reach out to an asylum lawyer right away. If you're ready to take the next step and get help with your asylum case, call my office today. That number is 713-909-0401. Remember, we help people all over the country, so it doesn't matter where you live. Call us now to schedule an asylum strategy session so we can help you secure your future in America through asylum. Again, I'm Brian Manning, and it's an honor to serve you in your asylum journey.